मिस्टर, यहाँ नेतागिरी नहीं चलेगी।
नहीं, अभी रखे साहब पेपर।
रखे हैं तो रखे रहिए अपने पास। जो न्यायालय में मैंने आपको पहले पूछा था कि उसके बाद बहस शुरू जाने के बाद मैं समय नहीं दूंगा, और ये नेतागिरी यहां मत दिखाइएगा कि ये रखे और वो रखे। आपकी सहूलियत के लिए मैं ये पैराग्राफ 15 फिर से पढ़ देता हूं, ठीक है? ना पढ़ूं, जैसा आप बोले।
साहब पेपर भी रखे मेरे पास।
रखे रहिए सर, मैं कुछ नहीं जानता।
तो अभी
आपने न्यायालय में मूल दस्तावेज प्रस्तुत क्यों नहीं किए थे?
ये है साहब, वहां से फाइलें गायब हो गई।
गायब हो गए, चलो ठीक है, चलो ठीक है।
और उसकी शिकायतें भी कर रही है मेरे साहब, गलत ही बोल रहा हूँ।
है?
मेरी फाइलें गायब हो रही है, सब मिली भगत हो।
आपने कहा कि आपकी मूल प्रति मुझसे मतलब आपसे गुम हो गई है, ये आपकी गवाही लिखी गई है।
मूल की जो शिकायतें करी थी
और अभी आप कहते हैं कि फाइलें गायब हो रही है, और अभी आप कहते हैं कि मूल आपके पास रखी हुई है। ऐसी बातें कर रहे हो यार? मुकदमा लड़ रहे हो कि शिकायतों के लिए आए हो?
साहब रिपोर्टें करी थी उनकी।
रिपोर्टें करें कि नहीं करी, जो दस्तावेज की बात हो रही है, इसलिए आपको पहले वार्निंग दी थी मैंने। ये यहाँ पे ये आपको अपना अपने पंचायत में नहीं खड़े हैं,
कोर्ट में से फाइलें गायब।
मैं आपको कंटेम्प्ट का नोटिस दे दूंगा। झूठ बोल रहे हैं आप यहाँ पे खड़े होके। एक तरफ कहते हैं कि मूल दस्तावेज गुम हो गए, दूसरी तरफ अभी कहते हैं मूल दस्तावेज आपके पास रखे हुए हैं, फिर कहते हैं कि न्यायालय से दस्तावेज गुम हो जाते हैं, और मूल दस्तावेज कहते हो कि मेरे पास रखे हुए हैं। मानना कर रहे हो कोर्ट की, और सर आप झूठ बोल रहे हो। आप घर है क्या? जो मर्जी आओगे वो बोलोगे। 220999/2023. Shri Manish Das, senior advocate with Shiva Mishra, counsel for petitioner. The applicant is present in person. The applicant was informed well in advance as to whether a specific question was put to the applicant as to whether non-applicant as to whether he would be in a position to answer the legal query, which may be the legal argument which shall be raised by the counsel for the petitioner or not. He submitted that he had engaged a lawyer, but after taking fee, he is not appearing. And accordingly, he has already made a complaint before Bar Council against that lawyer. Full stop. Thereafter, this court gave an option to the non-applicant that if he so desires, then this court can provide the services of a lawyer on the state expenses. But he insisted that he would argue the case on his own. Full stop. Accordingly, it was once again clarified that once the arguments starts, this court will not adjourn the case. But he again and again submitted that he is in a position to answer the legal queries. Accordingly, under these circumstances, this court was left with no other option but to hear the submissions made to hear the arguments of the counsel for the applicant. This application under section 482 of CRPC has been filed seeking the following relief. By referring to the deposition sheet of the non-applicant, it is submitted by counsel for applicant that the non-applicant produced 2 photocopies of 2 documents during his cross-examination.
3 documents, P15 to 18.
In the examination in chief. Examination in chief ही चल रहा था. He produced कितने documents हैं?
P15 to P18.
15.
4.
Produced 4 photocopies of 4 documents and tried to get it exhibited. It was objected by the counsel for the applicant that since those documents were not filed along with the charge sheet, therefore, in the light of section 294 of CRPC, he cannot be taken by surprise. And further, the non-applicant has not brought the original documents and he wants to get the photocopies exhibited without seeking permission to lead secondary evidence. Next, however, the trial court rejected this objection on the ground that merely by exhibiting the document, it would not mean that those documents are admissible in evidence, and the accused persons shall have every opportunity to cross-examine the complainant, and accordingly permission to mark the documents as exhibit P15 to P18 was granted. Challenging the order passed by the court below, it is submitted by counsel for the applicant that the evidence, that a primary evidence has to be produced, and in case if the party is not in possession of primary evidence, then he can seek permission to lead secondary evidence by filing an application under Section 65 of Evidence Act. In the present case, no application was filed. Even the ingredients of Section 63 of Evidence Act were not satisfied, except by saying that the original copy has been misplaced, coupled with the fact that the documents were not filed along with the charge sheet. Therefore, the complaint case. Therefore, the trial court should not have allowed the complainant to exhibit the documents. Per contra, it is submitted by the non-applicant that his original documents are being stolen from the court. However, he submitted that he is in possession of original documents of exhibit P15 to P18. The submission heard the learned counsel for the parties. The submission made by the non-applicant is contemptuous. On one hand, he has stated that his original documents are being stolen from the court, and on the other hand, he stated that the original copy of the documents in question are in his possession. If the non-applicant is in possession of the original documents, then how he can allege that the original documents were stolen, are being stolen from the official court record? Full stop. Furthermore, accordingly, the attention of the non-applicant was drawn towards the statement made by him before the trial court to the effect that the original copy of exhibit P15 to P18 has been misplaced, but he submitted that he is in possession of the original copy of the said documents, be that whatever it may be. Whenever a person wants to lead secondary evidence, then he has to file an application under Section 65 of Evidence Act seeking permission to lead secondary 65 Evidence Act. Secondary evidence means Section 63 of Evidence Act reads as under. Therefore, first of all, a party to the litigation has to satisfy that the document on which he wants to place reliance falls within the definition of secondary evidence, which has been defined under Section 63 SIA sentence. Section 63 bracket 2 of Evidence Act provides that, inverted comma, copies made from the original by mechanical process, which in themselves ensure the accuracy of the copy, comma, and copies compared with such copies, inverted comma, close. A 63.2 and 63.3 provides that copies, inverted comma, copies made from or compared with the original, inverted comma, close. Therefore, the trial court, before granting permission to lead secondary evidence, has to ensure as to whether the document on which the party wants to place reliance falls within the definition of secondary evidence or not. Merely by saying that the original copy has been misplaced, therefore the complainant tried to get it exhibited. The trial court, without considering the provisions of Section 63 and 65 of Evidence Act, permitted the complainant to exhibit the documents by saying that merely because a document has been exhibited, that does not mean that it has been admitted in law. What is forbidden under law should not be done. Full stop. By adopting such a method which has been adopted by the trial court, in fact, the trial court has caused irreparable loss to the complainant or non-applicant also. By exhibiting the document which cannot be read in evidence, being violative of section 65, 63 and 65 of Evidence Act, the trial court has also taken away the opportunity from the complainant to rectify the mistake, be that whatever it may be. Once a photocopy of the document cannot be taken on record unless and until the same is proved to be a secondary evidence, and unless and until the permission is granted by the trial court. Under these circumstances, this court is of considered opinion that the trial court committed a material illegality by rejecting the objection raised by the counsel for the applicant with regard to marking of exhibit P5, P15 to P18 as exhibits. Accordingly, the objection overruled by the trial court in paragraph 15 of the deposition of the non-applicant is hereby set aside. The photocopies of exhibit P15 to P18 are directed to be removed from the record. With the aforesaid observation, the application is allowed.
Item number 36, डॉक्टर अनवास श्रीवास्तव, श्री दीपेंद्र सिंह राजपूत।
नहीं देखेंगे, हमने आपसे पहले पूछा था कानूनी प्रश्न का जवाब दोगे तो हम सुनेंगे। आपने नहीं, हो गया आपका केस।
साहब मैं हाथ जोड़े की बिनती,
आप कुछ नहीं, आप कुछ नहीं।
मैं भी कुछ निवेदन वकील साहब से कर सकूं, मैं भी कर सकूं।
हाँ करिए ना, आपसे पूछा था मैंने। आप तो ये कहा गया कि मैं फलाने के खिलाफ शिकायत करता हूँ, फलाने के खिलाफ शिकायत करता हूँ। आप तो यही पे उतर आए।
निवेदन मैं भी वकील साहब से कर सकूं साहब?
नहीं, वकील साहब से मत करिए, हमसे करिए।
तो
वकील साहब तो आपके निवेदन सुनकर कुछ नहीं कर पाएंगे।
जमीन
आपसे जो प्रश्न, जिस मुकदमे का जितना प्रश्न है उससे बाहर आपसे कुछ नहीं सुना जाएगा।
वही पूछूं
आपको ये बता, हो गया मुकदमे का आदेश हो गया, अब आप ये बताइए इस मुकदमे में क्या प्रश्न है?
ये प्रश्न है साहब के 1990 में
आपसे ये प्रश्न है कि फोटोकॉपी आप दस्तावेज की फोटोकॉपी पेश कर सकते थे कि नहीं? बस इससे इधर उधर मत जाइएगा।
साहब फोटोकॉपी में बोल तो रहा हूं कि दोबारा निकाली है, वहां से गायब हो जाती है कोर्ट से साहब।
अच्छी बात है ना, हो गया।
और वो शिकायत भी मैंने कर दी वकील साहब की, यही कोर्ट में जबलपुर में।
बहुत अच्छा किया आपने।
अब ये निवेदन साहब मैं हाथ जोड़ करना चाह रहा हूँ कि 1990 में बोल रहे हैं कि पूरा भुगतान कर दिया, जबकि इससे मेरी कोई जानकारी नहीं।
मुझे तथ्यों के ऊपर नहीं सुनना है, क्योंकि ये अभी मेरे क्षेत्राधिकार में नहीं है। आप 4 घंटे पूरी अपना दुख बताएंगे भी तो मैं आपके आंसू नहीं पोंछ पाऊंगा। ये समझना चाहिए आपको। ये जो आप बहस कर रहे हैं वो आपको भी निचली अदालत में बहस करनी है।
साहब बहस तो सब जगह चल रही है।
अब आप जा सकते हैं, धन्यवाद। नेक्स्ट
आइटम नंबर 36,
पेपर भी लाया हूँ साहब मैं तो।
अच्छी बात है,
फर्जी पेपर बनी है।
अच्छी बात है। ये देखिए वहां